So good afternoon and welcome. I'm Marco Sassoli. I teach at the University of Geneva, and I'm very pleased to welcome you. And I would like to thank the Geneva Academy and its director, Robert Rode, and the CERA, the Centre d'Enseignement et de Recherche en Action Humanitaire, to have organized this not only book launch, but really presentation. By the way, we could launch two books, Justice, Law and War by Shane Darcy too. Perhaps I first introduce, if you agree, all the panelists, and we decided to proceed in reverse seniority. Therefore, it will be Sharon Whale who will first speak, as also her book is the officially launched one, The Role of National Courts in Applying International Humanitarian Law. I'm obviously embarrassed to say how good this book is because I was the director of the thesis, so I will speak better of his book because I am still in Geneva tradition, a rather Calvinist person who thinks that things must impress from themselves and you shouldn't be too laudable of things, in particular if you were involved yourself. She will speak about the role of national courts in applying international humanitarian law. Then there will be Shane Darcy, who teaches at the Irish Centre for Human Rights in Galway and has just published this book about justice, the law of war, law and war, the judicial development of international humanitarian law. And finally, we will have the director of the Academy, Robert Rode, more in his function as a former judge of the Special Tribunal for Lebanon, who will speak about the role of hybrid courts. Now, obviously, at least the lawyers in this room are totally convinced of the crucial role of courts, in particular in this field of international law. We will achieve, I would say, a minimum of rule of law in such fields only if courts have an increased role in applying those rules, and if they are not, as they are traditionally, mainly self-applied rules, self-applied by states, armed groups, and those people who fight. So we lawyers are fetishists, of course, courts, because, except some critical studies people, think that a serious legal system is implemented by courts. And we also think, and I think in both your books you also show that this is slightly an illusion, but nevertheless better than what states do, that courts are not, or at least less politicized. The application of the law by courts is less politicized. Now, we know that in many fields of international law, there are no courts, and international humanitarian law is today, whenever it is implemented by courts, indirectly implemented by courts, courts dealing mainly with something else, with human rights. We do not discuss that today. Implemented through individual criminal responsibility by international and domestic criminal courts, and finally by domestic courts which apply domestic law and international humanitarian law in one way or another, can be part of domestic law or allowed to interpret domestic law. Court decisions are very important to understand and even in reality to develop the law, and we don't have specific humanitarian law courts. Probably one of the greatest illusions of the theory of sources is that jurisprudence is only a subsidiary source, while even in a branch as humanitarian law, every one of us refers very much to judgments, and we need them. I think the categories Sharon Weil suggests in her book, that somehow courts have always are somewhere between utopia, apology, and technical application of the law. I would add over-bureaucratization, especially in international courts, but this hopefully does not so much influence substance, but in my view, their credibility. And I think this is also true for, but you will tell us, for international and hybrid courts, that they are always in the dilemma where either they dream or they simply give somehow a little credibility to what states anyway want to do. So I'm looking very much forward to hear the three of you, and I would like to thank so many of you to have come to this subject, which sounds very legal. Please, Sharon.
Okay, so thank you very much, and thank you for coming. Thank you for Sarah and the Academy, and especially thank you for Marco Sassoli, who was my supervisor at the University of Geneva, with whom I did my PhD, and without whom I've never had this result. No, but it's true. So 1 minute I can... Okay, so now, of course, I cannot describe a book in the 15 minutes that I have. Maybe I will give you some appetite to read it. And as you can see, it's not very long. Yes. So it is meant to be read from the beginning to the end, like a roman. You know, you can read it before going to bed. It's interesting. No, I'm kidding. Not before going to bed. You will fall asleep maybe too early. Anyway, so I want to explain to you, first of all, where came my idea, why I did this research, and then to give you some general explanation of the book. So 5 years ago, when or maybe even more, when I started my PhD and my thinking about what to do, I was quite involved in working in Israel and Palestine with human rights lawyers and different NGOs. And at that time, we had many cases going to court. So whether I did the research on the military court in Palestine, in Israel-Palestine, or whether the Israeli High Court. And so I had very much this lawyer point of view, and the fact that you try to go to the court, you know, to obtain something. So what was particularly interesting in this case of national court, what I'm doing, which maybe is slightly different with international court, is that lawyers that want to go to court, normally in in democracies at least, you have a functioning court that should be functioning according to the rule of law, which means that judges should be independent and impartial. You should allow access to victims to ask for redress. It should apply the law equally to all the subjects that are before it. So this is what we learn, you know, first year of law study, and there is the rule of law. Now, at national level, this is more or less functioning in the different fields of law. If we think about family law, penal law, tax law, whatever. You have a court, and you know, more or less, courts obeyed by the rule of law, lawyers can bring cases, and you have decision. So on the one hand, you had this at national level, but on the other hand, in these cases, they are asked to apply international law, international humanitarian law, which is inherently political, because it is done by state, and usually it is enforced by state. So you have this very contradiction, really by definition, between the court, which is supposed to apply the law in an impartial, independent manner and everything, and the law in itself, which is full of political consideration, and especially in armed conflict. I think we can hardly imagine a situation more political and more sensitive than a situation of armed conflict or emergency situation. So this was interesting for me to look at and to understand when lawyers go to court, what do I do expect and what happened through the decision. So I wanted to try to establish a kind of a theoretical framework in order to understand how courts function when they are asked to apply the law of international humanitarian law in cases related to armed conflict. So very soon I started to read other jurisdictions, then Israel-Palestine, and then I had, the UK cases, US cases. At the time, you started to have the jurisprudence of the Guantanamo cases. And of course, I think I read many cases, national cases dealing with IHL. And from reading all these cases, so I tried to establish this theoretical framework of function. And then I identified a spectrum, which of course is a proposition. Maybe there are other functions, and I hope maybe it could be a basis for future study. So the spectrum which I identify, I have 5 functioning. The first one is the apologist role or the legitimating role. Then you have the avoiding role, the feral role, limiting role, and utopian role. I will come in a minute to explain in a sentence each one of them. So once I had this, developed this spectrum of functioning, in the book, so every chapter describes this function with many cases and try to analyze this in light of the rule of law. Now, of course, why a judge will function like this or like this, why would they choose any of this function, is related to many factors that, again, it's not an exhaustive list. This, for sure, will be open for further study. So this especially identified a different role. Now, why judges will choose any of this depend on their own position in a state, their own institutional position vis-à-vis the executive. It will depend on the demand of public opinion for accountability. Because, that during armed conflict, usually people give a bit of carte blanche to the executive to do, especially at the first time, at the first moment of the conflict. And then the more time have elapsed, more you have the media, civil society demanding accountability, bringing facts that were unknown. So you have this question of time where a case was brought. You have the question of simply whether or not national judge know IHL, which is also a question, because when I studied the cases from the Belgrade court, you could see things that they can apply simultaneously, Protocol 1 and Protocol 2, and I think that, even if you are in the first week of your study, you already know that you don't do this. So this is, of course, also a question, whether national judges know enough IHL, whether the lawyers bring the cases enough detail, and so on. So there are many criteria. But again, as I said, it is less about this, although of course I touch it, but more about the different function. So now in the coming 5 minutes that I have, I will describe more or less each of the function. Again, it's only to give you a taste. And in the book, there are really a very critical analysis of the decision in which I read the decision within the political context. It's quite the opposite of what we usually do at law school, that we only see the paragraph, and we don't know where it comes from, but this is what we remember. So here in the book, it's really a deconstructing, let's say, the arguments in light of the political context in general and the specific political context of the litigating party and the court. So the first function, the legitimating function or apologist function, as I defined it, is when court really apply the law in a quite distorted manner in order to legitimize, to give this, this stamp to the executive that what they did was legal when the action was illegal. So if you have a norm that say X is illegal, and they will say, no, it's legal. Just for imagine to say you cannot torture, and then a court will say, yes, you can torture. Okay, this is just a basic, it's not an example. But this is the apologist role. So, of course, from the rule of law perspective, this role is very problematic. I don't need to speak too much about this because it developed distorted jurisprudence that can be then cited by other courts, etc. So from the point of view of IHL and the rule of law, this is very problematic when a court supports in this manner its executive. So maybe a way better for court in very sensitive political issue where a court feels that it cannot intervene will be the avoiding rule, which is the second function. Here I have a case and it said, this is a political question, and maybe some of you know the political question doctrine, the act of state doctrine, and the court is saying, this is not my role to give a decision on this case, and I don't accept it. So it avoids the case, although of course there is a legal answer, but institutionally the court decides to avoid it, and then they leave it to the political area, and then NGOs can keep the discussions and civil society, but at least you don't have this rubber stamp that something was illegal when it was not. And a small example, for example, will be in Israel, that the High Court decided that whether the settlements are legal or not, which there is an explicit provision in IHL, so we know it's illegal, but the court will say this is a political question, I will not deliver a decision on this. So again, from the rule of law perspective, it's a problem because we prevent access to court, and also it will depend who are who are asking to implement the law and who not. We can see this in the Alien Tort Statute in the U.S. that depending of the victim, depending of the perpetrator, you have this double standard. So the next step of function will be the deferral function, which I think it's better from avoiding, is when a court will accept the case. He will say, I'm the forum, he will not reject it. But because of, again, very much political problems during conflict, he will say, okay, I take the case, this is the law, but I defer back to the government to decide on this specific case. And in this way, when it defer back to the government, then the government knows that the court, is there, and maybe if he will not follow the law, the court will take again the case and then will impose a better limit. But at this stage, it's kind of a dialogue between the judiciary and the executive. So this is, I think today we can observe this trend, that court, if before they avoided IHL question much more, today more and more they agreed to take case and to open a dialogue in the government. It doesn't mean that they will give remedy, but at least, so the danger is that at the end, the executive will decide to do whatever he decides anyway, and at the end, it's just legitimizing again. But the positive thing for the lawyers is that they can come back to the court and the door is not closed to them. So this is the deferral court. And then you continue to the limiting court, the limiting role, which is obviously from the rule of law perspective, the favorite one, which means that if the state is violating the law, the court will impose a limit, as it does in different, in other fields of law. So this is the limiting court. I will not go into much detail on this because it's quite obvious. And then I have identified another function, which is very rare, but it exists, and it is the utopian role, in which court goes even one step further and will render a case which is beyond what the requirement of the law in order to protect the individual. So this is the utopian. Here they will introduce moral judgment and ethical judgment. Some of you who know the Ferrini case, I won't go into detail, but this is an example. So here on this question, I know not everyone will agree with me, but I had quite a positivist attitude vis-a-vis the courts, especially in IHL, that I would like courts, to apply what we have and not necessarily go and develop even more. Because if we read closely the cases in which they gave this utopian decision, in a way, it was also depending on the victim, depending on the responsible. So again, we just give too much open door for the double standards. This is why the utopian role is not my favorite, but this is, I know that some people don't agree with me on this point. Voilà, so this is the different function, and if you have a question, we could open it later.
Thank you. Thank you very much. And now I give the floor to Shane Darcy on the international courts, where I would feel a lot of things are, in my view, similar, but that's what is your opinion?
Okay, well, first of all, I'd just like to say thank you to Sharon and also to Sarah and the Academy for inviting me to participate in this symposium. And I'd like to start by, well, congratulating Sharon on the publication of the book and on the substance of the book. It's a really rich exploration of the issue of national courts applying international humanitarian law. It makes sense of these often incoherent and contradictory approaches that national courts take, and the theoretical framework that you construct is really useful in trying to analyze the various jurisprudence across the national courts that you look at. I have one criticism of the book. I hope it's not inappropriate, but it's that I didn't get to read it until I was finished my own book. As in, both books have come out within a few months of one another, and I would have benefited hugely from reading this book while I was working on my own similar but very, very different in some ways text. My own work recently has looked at the judicial development of international humanitarian law, so the last issue that you touched on there, and has focused primarily on international courts because, of course, in the international legal system, international courts tend to carry a greater weight, or the decision of judicial bodies of an international nature, such as the International Court of Justice or the ad hoc tribunals, have tended to be more influential and carried greater weight in the international legal system. So what I do in the book is try to explore various ways in which such judicial bodies have contributed to the development of international humanitarian law. What I'd like to do in this few minutes that I have is try and just connect a couple of the themes that emerge in both of the books and give a little overview, I suppose, of what I do in my own. I mean, Sharon in the introduction talks about how national courts, because of the limited role given to international bodies, the application of IHL has often fallen to national judicial bodies. But very often, as she says, this has proven unsatisfactory. And she concludes in one of her chapters, chapter 2, she talks about, well, in these particular cases, with the targeted killings cases, it says, well, only one avenue remains available, an international court. So there is this relationship between the two, and I think when you talk about states' views as to the role of judicial bodies in applying IHL towards national courts, similar views exist with regard to states as regards the role of international courts applying international humanitarian law or dealing with issues arising during situations of armed conflict. States have demonstrated a perennial wariness about giving courts jurisdiction over situations of armed conflict. If we look at it in a historical sense, international courts that have had such jurisdiction, whether it be over war crimes, have been given a very carefully circumscribed jurisdiction by states. Now, there's no question that the past 2 decades we've seen a proliferation of international tribunals, primarily international criminal tribunals, with jurisdiction over grave breaches of the Geneva Conventions and war crimes in non-international armed conflicts also. Some have described it as the judicialization of armed conflict. But if you look at it historically, and I do a little of this in the book, you see that states have been very, very hesitant. The idea of an international court prosecuting war crimes is not a new idea. It's been around for 150 years at least. And we can see the various stalled or failed efforts in the aftermath of the First World War, attempts to create international bodies or to have prosecutions for war crimes did not match up to the hopes or the expectations that may have been there. In the aftermath of the Second World War, of course, we had the creation of the international military tribunals for Nuremberg and Tokyo, ad hoc temporary bodies with a jurisdiction that was specifically directed at the Axis powers. Around that time as well, we saw the development of the Geneva Conventions, and the role for international courts in applying those treaties or interpreting those treaties was something that was proposed during the drafting of the conventions. It was said that the court, the ICJ in particular, should have compulsory jurisdiction over disputes. That was a proposal that was put forth, and they couldn't get agreement on that. The United States and others were opposed to the idea of any compulsory jurisdiction. I think the Soviet Union said it would be against the UN Charter to do so. And what we saw was, as was referred to, the dogma of state sovereignty prevented this from taking place. So the ICJ has no compulsory jurisdiction over issues of international humanitarian law, although we have seen it addressing such issues in a few cases. However, we have seen, as I've mentioned, in the past 2 decades, the creation of the international criminal tribunals, prosecution of individuals, including high-ranking political and military leaders, for war crimes, before the ad hoc tribunals for Rwanda, the former Yugoslavia, Special Court for Sierra Leone, and also, of course, the creation of the International Criminal Court. But the jurisdiction of these bodies, well, for some, they're obviously temporary, addressed to a specific conflict. The ICC is a permanent institution, but it's a treaty-based court, and it has a limited jurisdiction based on those states that are party to it, but also built into it are certain thresholds. So it would only deal with war crimes of a particularly serious nature. And then, of course, with the complementarity regime, it allows national states to have the first go, if you will, at prosecuting individuals. And the Security Council has a role in there as well. But they have greatly contributed in this short period of time to the development of international humanitarian law. Another development, I think that was alluded to earlier, is the role of human rights courts or bodies, and whereby they are looking at situations of armed conflict, sometimes applying IHL, but usually through a human rights framework, but addressed to situations of armed conflict. And I don't think that was by design, and it was probably a reflection of the insufficient enforcement machinery within international humanitarian law itself. But the bulk of the work that I've done in this book sort of relates back to the last category that Sharon talked about, and that is judges as law developers, as you put it, the utopian role that you refer to, whereby judges go beyond settled practice, perhaps conflicting with a government stance, which you say will conflict with rule of law principles. And in the book, Sharon talks about how it's almost a byproduct, if you will, of a problematic international legal order, whereby the legislative process and the scope for elaboration is limited. And these are themes that I've certainly addressed in the context of this particular book. One of the questions that sort of occurs was, well, do judges create law? And Professor Sassoli talked about the illusion of judicial decisions being subsidiary sources of international law, as we see in Article 38 of the ICJ statute. And there's no doubt that judicial decisions, judgments, are in many ways the lifeblood of international law. And in the context of international humanitarian law, there's been 2 great periods where we've seen judicial elaboration of the laws of armed conflict. The period immediately following the Second World War, where we had the international military tribunals, but also thousands of national military tribunals holding trials. And then, more recently, the period beginning in the 1990s. Theodore Meron said, I think in 1998, he said, IHL had developed more in the 5 years since the establishment of the ICTY than in the previous 50 years. So we see these periods where there's great activity and application of international humanitarian law by judicial bodies. And what they have done in terms of developing the law as well, clarifying the meaning and scope of particular rules. The treaties, the Geneva Conventions and protocols, they're often described as abstract rules, and then the courts take these and apply them in concrete circumstances. They've also assessed the question of the customary international law status of particular treaties or particular rules. The international criminal tribunals have at times had to assess whether criminal liability attaches to a particular breach of international humanitarian law. And also questions as regarding the application in the first place of particular bodies of international humanitarian law or particular treaties, because of course there's different criteria governing their application. And these judicial decisions have been, in some instances, quite influential. They've been followed by other courts and tribunals, followed nationally, and sometimes states have adopted the positions taken by international courts, and these have subsequently been reflected in treaty-making efforts. The Rome Statute stands out in particular. Some of the key developments, and I'm sure people will be familiar with these, are defining what is meant by an armed conflict, clarifying issues around the meanings of a belligerent occupation, definition of what a protected person is, ICTY in the infamous Tadic case, which runs throughout the text, clearly the most influential in terms of war crimes applying in non-international armed conflict. And that decision certainly influenced the drafting of the Rome Statute of the International Criminal Court. Other issues include the application of so-called Hague Law in non-international armed conflicts, definitions of torture, definitions of rape. The application of human rights in situation of armed conflict is something that can be described as a judge-led endeavour. Why do we see these developments taking place? Well, sometimes in more recent times at the ad hoc tribunals, for example, some of the judges said, well, we had to elaborate. We were given a very bare-bones statute. We needed to develop law in order to apply and proceed with the cases in hand. Sometimes, clearly, judges have expressed a desire, perhaps not at the time, maybe subsequently, to progressively develop international humanitarian law. And several judges from the ad hoc tribunals, Cassese, Judge MacDonald in particular, have talked about the need to develop international law, the fact that the law of war has not kept pace with developments in conflict itself has demonstrated a need to move the law on. And how have they done this? Well, through interpretation, through application of particular facts, and customary international law has played an important role. So interpreting what customary international law is, often perhaps not with sufficient evidence to be the case, but nonetheless proving influential in later applications. There can be problems, of course, and Sharon has alluded to some of these in her work about the risk of double standards. States might see this as encroachment upon their role as the creators of international law. As well, we may have, given the proliferation of international courts, judges are going beyond the letter of the law. Perhaps we may have conflicting decisions or fragmentation, as it's been described. And there are certainly instances where international courts have taken a different view, perhaps, of certain rules of international humanitarian law. We see this in international criminal law as well, with the aiding and abetting issue before the ICTY and the Special Court for Sierra Leone. In terms of judicial development of IHL, it has been selective as well in terms of its approach, because the courts can only deal with the cases that are before them, so there's been a lot of focus on protected persons and issues like that, and less so on methods and means of warfare, conduct of hostilities. Some would say, well, that's certainly something that more powerful military states are happy to see that take place. There are, of course, instances where courts have tried to progressively develop the law, tried to push a particular angle that has not proven successful, that states have not agreed with the law as has been stated by the court. The ICTY in the Kupreskic case tried to advance the law relating to reprisals, and the UK, for example, stated that they did not agree with the position that was taken by the court in that. So in some ways, judicial development, whether it can be called judicial lawmaking, is sort of a halfway house. It depends on how what is said in those judgments, how that is received subsequently, in the sense that states almost remain the ultimate arbiter as to whether something becomes international law. But of course, application of treaties and in their interpretation can just sort of become part of the accepted interpretation, so it can be more difficult for states to challenge that. There are, of course, instances where the international courts may have simply had a wrong interpretation of international humanitarian law. We can certainly see some examples of that. So that's sort of a quick overview of how I approach this in the book, and there's certainly numerous instances where judges have given life to international humanitarian law, perhaps progressively developed it beyond what states may have agreed to, but in some instances, states and others have accepted that. They have accepted the push that they may have been given by an international court. In others, they may not fully agree. But I think certainly IHL has been certainly influenced greatly by the contribution of international and national courts, but from the perspective of this work, more so by international courts. I think I'll leave it at there.
Thank you very much. So now I give the floor to Robert Rode.
Thank you. So I will not speak about the book I have not written yet. No, I've not written a book of my experience on the SCL. I'm writing this book, but I need some time and distance in order to be able to present it here and to write it first. But more seriously, everybody is aware actually of the topical role played by the special tribunals in the development of international humanitarian law. Dr. Darcy has already addressed parts of these contributions. In these brief remarks, they will be brief because Marcus and myself have a very important meeting at the law faculty in a couple of minutes, so we will not stay longer than 1:45. In these brief remarks, I will concentrate on the institutional role of special and mixed tribunals and their relations with states' responsibility in implementing the obligation in international humanitarian law. So very institutional approach. I have to say that I will be critical on the role of ad hoc tribunals, mixed and special. I will come back to the distinction and the danger which the setting up encompass. This naturally does not in any way intend to negate or even diminish the importance and the merits of the two ICT, in particular the Yugoslavia and Rwanda tribunals in the development of international law in general, international humanitarian law in particular. I will not address the question whether they have contributed to the improvement of international criminal law or criminal law in particular, because I'm more skeptical on this, but that's not the issue here. So this contribution of special tribunals to the development of IHL are beyond discussion or reconsideration, even if naturally some decisions deserve to be criticized in their substance. I'm interested here, as I say, in the processes and in the risks the processes involve. I must just add that I've been, as Marcus Sassoli has mentioned, for 2 years a judge with one of the mixed tribunals, the Special Tribunal for Lebanon, and before 20 years a domestic judge with the Geneva Cour de Cassation, which doesn't deal very much with international humanitarian law, but which deals a lot with human rights law, naturally, as every jurisdiction in Europe now. First, a word, perhaps for those who don't have completely the concepts in mind about special and mixed tribunals, because it's in the title. To this date, 6 mixed tribunals have been established. I just mentioned the places: Kosovo, Bosnia-Herzegovina, Cambodia, actually, Sierra Leone, which was mentioned, Timor-Leste, and finally Lebanon. A 7th tribunal is in discussion, again on Kosovo, but it's not on war crimes this time. And actually, in the background, you have the whole discussion about the Syria tribunal, which is probably the most important topic these days on mixed tribunals. Some of these mixed tribunals have to deal with undisputed international crimes, genocide for Cambodia, naturally, war crimes for Kosovo and Bosnia-Herzegovina. The exception being precisely the STL, Special Tribunal for Lebanon, whose jurisdiction is limited to terrorism in a context which in no way could be considered part of international humanitarian law, because it's only a terrorist, an ordinary terrorist act. The others have, as you know, have jurisdiction on war crimes, as is the case for special tribunals, for ex-Yugoslavia and Rwanda. Why are we making a difference between mixed and special tribunals? not because mixed tribunals would be general, like in contrast with the special tribunals, but mixed tribunals which are as much ad hoc as the so-called ad hoc tribunals of the first generation. The mixed tribunals are mixed because of the composition of the tribunal and the applicable law. And both in composition and in the applicable law, and actually in different settings depending on the tribunal, you have part of international law and part of domestic law of the country concerned, or the countries, but for the moment it's only country by country. Here we see a first paradox when we consider humanitarian law. Humanitarian law is international law par excellence. And it's a paradox to see with mixed tribunals national law reintroduced in the jurisdiction, adjudication of international humanitarian law cases. National law can be reintroduced in the procedure, and that doesn't directly affect the application of international humanitarian law, but national law can also be introduced in the substance. And here you have a de-internationalization of the applicable law. And it's one of the challenges of a mixed tribunal. It's, on one hand, a technical problem. It's also a political problem, which I will address in a few minutes. There is a lot of ambiguity around mixed and special tribunals. And since Sharon Weil has addressed the question of domestic jurisdiction, I will just reflect 1 minute on the relation between the role of national jurisdiction in implementing AHL and the role of mixed tribunals. And I will start from a key publication to which I went back and which surprised me a little bit. It's not a doctrinal work with fantasy, as we all know, but it's a key publication. It's the commentary to the study of customary international humanitarian law, edited by the Red Cross, and the commentary edited by Louise Oswaldbeck, who's a former director of the Academy, and Jean-Marie Reckners. And in the commentary on Rule 158, I have read these words, and I quote them. State, I quote, may discharge the obligation to investigate war crimes and prosecute the suspects, which is an obligation under customary international humanitarian law, by setting up international or mixed tribunal to that effect. And frankly, I find it quite surprising. It's a pity that Louise is not in the room, because I would like to have her opinion on this. For me, it's a little bit strange approach since international tribunals are not really set up by states, but they are mainly set up by international body, especially the Security Council, or if it's not directly by the Security Council, it's by an agreement between the Security Council and states, where the Security Council plays the main role. So it's a little bit strange to consider that in order to discharge the obligation, states would set up international tribunals, which in reality they don't set up. They can contribute, or one of the states contributes to setting up, but it's not setting up by states. And these confusions, in my view, reveal the ambiguity around the very status of special and especially mixed tribunal. They are presented in this important publication as a kind of proxy of the state, which can then be relieved of the obligation under customary international humanitarian law by participating through the Security Council or through the General Assembly, etc., participating in the setting up of tribunals. But I wonder if it's not a lure, and perhaps it's a lure, and also it's also a danger. Mixed tribunals are the result of political decisions. The ad hoc encompasses two dangers, in my view. First, the danger of selectivity, which has been mentioned already, but I take it in a broader meaning than selectivity you addressed before. Selectivity has been identified from the outset by the commentators to the ICTY status and existence. And I came back this morning, I wanted to read again what Jean-Jacques Bissab has written in 97, after having been for 2 years already judge with the Appeal Chamber of the ICTY, and he speaks very well of selectivity from the outset. But that's not the point here, on the most important point, because it concerns less international humanitarian law. But what concerns international law in general, international humanitarian law in particular, is the danger of relativism, not in the common meaning of the word, but in the sense that guided by the conditions under which the tribunal have been created, judges who are not sufficiently independent in their mind, and sometimes in their training, which is important, may envisage variations in the applications of the general principles of law and in international humanitarian law in particular. Naturally, the decision which comes to mind to everybody, I think, in this respect is not a real judicial decision. It's a prejudicial decision. It's a decision not to prosecute the alleged war crimes committed by the NATO forces in Kosovo during the war of 99. It has been much discussed. I don't want to address the substance, but to mention a case where there has been a suspicion, actually, of political bias because of the conditions under which ad hoc, not a mixed tribunal, was set. And the other point I will just mention, because very often it's not mentioned, but when you experience a life in the national tribunal, it's everyday business, is the funding. The funding is a black box in many tribunals. If you try to, because I made the research this morning, if you try to know exactly what's the budget of the ICTY, not to even to address a mixed tribunal where it's even more obscure, but the exact budget of the ICTY and the provenance of the budget, you don't have the exact figures. You can find some figures, but it's not as transparent as it should be. And don't mention even special tribunal. As a judge with the special tribunal for Lebanon, to this day I don't know who contributes to our salaries. And it's very important, naturally. Out of this respect, to come back to national courts and the ICC are on the safe side because they are not ad hoc. The same commentary to the AHL customary law, Rule 158, adds, after the quotation I made before, and I continue the quotation a few lines below, the International Criminal Court is the first international tribunal to be established by international treaty, we all know that, which bears no relations to war crime committed in a specific armed conflict. And so the commentary insists on the fact that the advantage of the ICC is not to be not ad hoc and to be not related to a specific conflict. And that's exactly the reverse for mixed tribunals and even for special tribunals. And perhaps unwillingly, the commentary points out the difference with special tribunal and the risk, in my view, involved in the establishment of special tribunals. As a provisional conclusion, because I want to allow for a broad discussion, coming back to books which were presented here. But in conclusion, in my view, special tribunals and mixed tribunals have certainly contributed to the development of international humanitarian law. This is, as I say, beyond discussion. But first, mixed tribunals, like national jurisdiction, can contribute to the fragmentation of law in general, international law, and international humanitarian law. It has been mentioned by Dr. Darcy. They're on the same side. National courts on one hand, special tribunals and mixed tribunals on the other hand. And probably that's what the commentators had in mind when they made this strange relation between the obligation to the states and the institution of mixed tribunal, in which the states are not involved. But on the other hand, special tribunals and mixed tribunals, because they are, unlike both national jurisdiction and the ICC, ad hoc and not permanent, are at risk of being instrumentalized, and the responsibilities which rest on the judge's shoulders are particularly weighty. That's my experience. And that's it.
Thank you very much. Does anyone from the panel want to react to another panelist?
I have maybe one word. First of all, thank you, Judge Roth, and thank you, Dr. Darcy. It was very interesting. I just want to put one small remark before you open the floor. When I was speaking about the utopian role of national court, I do think that there is an important role for international judges to develop the law, and maybe this is not the same for national judges. So just to make this, voila.
By the way, just one remark on the development of the law by judges. This is also an intercultural issue in the sense that common law has been developed by judicial precedent, but the situation is quite different in both national courts and international courts when we look on the utopian part, because the very essence of judicial development, it is, or at least I learned also they don't always do it, is that they decide their case. And by deciding their case, they develop precedent. And while especially international tribunals, as I always tell my students, they are afraid that they will disappear. And therefore they try to say everything they always wanted to say, especially the professors in the courts, at the occasion of a case. And this, in traditional common law doctrine, does not create precedent, because what only creates precedent is the ratio decidendi of the case, and not what they explain like a professor in his or her book. But this is often misunderstood in the interesting dialogue between lawyers from a common law background and from a civil law background, where normally jurisprudence has not this function. In common law, it has this function, but it has been somehow manipulated. I open the floor. Yes, please, ma'am.
Alessandra from the Institute, PhD in International Law, PhD candidate. Question for Dr. Exactly. Well, and actually, you mentioned utopian function, and you said that you went through a lot of cases, and you came up with these 5 functions, in particular the utopian one. So, do you have any example of a case in which this function was so standing, so evident for you?
Thank you for your question. So you want an example of the utopian function?
Yeah.
Specific. Okay. The particular case that I'm dealing with was the Italian Ferrini case. Now, I don't know the people who know about the case. It was a victim of the Second World War, and he went to his city, town court and asked a remedy for war crimes, which is absolutely okay, I mean, you know. But the thing was that he asked it in Italy directly from the state of Germany. And normally, in international law, you have this basic principle, which is named state immunity. So you cannot ask a remedy for a state's third state court. So what was very interesting in this case, that it went up until the last, the highest court in Italy, and Italy ordered, it accepted this, it ignored the immunity of Germany, and it says that because of this crime, because of the development of international criminal law, in order to make sense of this body of law that has been created, it would simply not make sense to have immunity, and for this kind of crime, people should have redress. So, of course, when you read this case, it's a wonderful case. I mean, why not? You know, a victim of war crime, they should have a remedy. But what was my problem in this case? That a less known case of 2 years before, the same court, but just not the same nationality of victim. This time, it was someone from Serbia, it's a Markovic case, that went to the same court in Italy and asked remedy for the NATO bombing in which Italy was a part of, saying that he was a victim of a war crime. So this case was even more easy because you went to the court of the state. You don't have any question of immunity. And here the court said, "Ula, war crimes, this is an act of state doctrine. I cannot look into the case." So you see, and 2 years later, not only it looked into the case, it even was ready to ignore one of the main principles of international law, which is immunity from jurisdiction of third state court. Now, I'm not saying that immunity is good or bad. This is not the question. I mean, you know, this is up to the international legal order to develop the law and to decide. But this double standard of the court make you realize that, you know, even decision that sounds so good really depend who asking them and in what circumstances. And therefore, I'm not sure that national courts should this is why I think that national courts are too much involved in specific interests that maybe the ICJ will have less. Maybe, I don't know, but maybe. So this, anyway, this is detailed in the, and there are other examples that you consider.
Yes, please.
So first, I would like to thank the panelists for the valuable presentations. My name is Omar. I'm from Egypt. I just wonder if where would you put the shielding role of the courts, the national courts, in the spectrum of the courts functioning that you have mentioned in your book? I mean, at some court and some national legislations, you find the courts are trying to function just to shield the alleged war criminal from the further prosecutions by the international courts, so they can benefit from the principle of double jeopardy. So in this case, would you put it in the legitimatizing role? Mm-hmm. Because I don't see as it's applying a distorting legal rule, but it's using the discretionary power to issue some mitigated sentences or lenient disciplinary measures. And I can only remember here the case of Ariel Sharon after the Sabra and Shatila massacre in 1982. Where would you basically put this shielding role in the spectrum? And again, do you think, Dr. Shan, that we could give any role to the international judge in supervising or scrutinizing the national court's jurisdiction vis-a-vis these kind of cases? Thank you so much.
Okay,
the second point just has been dealt with in the ICC statute. Yes, if it is just shielding, the court can proceed. But the court has no jurisdiction on your case.
But it's not necessarily show trial cases. It's not show trial cases. Sometimes it's an efficient case, but has some political dimension in it that work within the discretionary power and the margin of appreciation of the court that could issue a sentence that is legally correct, but it kind of have political dimension in there. So it's not a show trial.
Okay.
Yeah, I absolutely agree with your analysis that things are not also black and white, you know, and everything have to be analyzed within the political context. Now, the question of criminal cases, it depends, because it's not always only the judges. It's first of all the decision of a prosecution, the question of investigation. So whether or not it's the judge itself, actually in criminal cases, the judges are the last ones, and I'm not sure that necessarily it's the judge, they will distort the thing, you know, but maybe the entire procedure of whether or not it was the investigation, whether or not the case was even prosecuted. And in the book, I have the example of the Belgrade court, and they were working, this was exactly the examples, because they were working on the small cases, and other cases were going to the ICTY, and these were criminal cases. And so I examined the decision whether or not Serbia was involved in the genocide, you know, in Bosnia, and there was this Scorpion case. So it was very interesting to see the Scorpion case in Belgrade and how it was in the ICTY. And of course, court can have then the legitimating function. So the court, through the reading of the facts even, you know, to decide what a fact is relevant, whether yes or not. All this can bring to a legitimating function. It's not only whether or not you apply the law, but also how you read the facts, which are very important, and this is in the analysis.
You want to add something?
Yeah, I'm not sure I can add much more than the ICC's role in assessing complementarity and unwilling or unable. But if I could just come back to the point you made about the common law, I mean, that's something that has come up in relation to judicial development of IHL. I mean, after the Second World War, before Nuremberg, the prosecutors talked and made a comparison, said international law develops much like the common law. I mean, that was criticized because the idea was essentially to sort of justify the judicial development was taking place at the time, although essentially it was the Nuremberg Charter that was the innovation. The judges simply gave it their seal of approval. But you were right, we don't have that same doctrine of precedent. Plus, within the common law system, judges, they are bound by constitution, existing legislation. It's not an untrammeled power to create law. And the precedent, of course, is centuries old. I mean, it's been well established. So I think that sometimes if I hear an international judge making that comparison, you want to be cautious. But on precedent, of course, we don't have a formal binding doctrine of precedent in international law, but international courts in the area of international humanitarian have tended to follow, and there's a sort of informal consistency within and amongst the tribunals. We can clearly find examples where that has broken down in international criminal as well. IHL, we have the big issue of control over non-state actors, the difference between the ICJ and the ICTY and that, but they're almost, to me, the exceptions that sort of prove the unwritten rule of consistency.
Please. Philip? Sorry. Oh, you will be the next.
Sorry for that. I have a question about the various...
Present yourself.
Sorry, Philip Grant from Trial. About the various functions, Saren, that you mentioned, and the capacity of international jurisprudence to maybe dwindle down or put away some of these functions. Dr. Darcy mentioned the ICC complementarity principle, could discuss about the role of the ICJ, but I'm really here talking about the role of international human rights bodies, universal or regional courts or UN system, for example, and the capacity that they have through their jurisprudence to scale down some of the more bizarre functions that you mentioned. It's not an emerging body of jurisprudence, it's a growing body of jurisprudence. There's quite a lot out there already. So how do you see that in the future? Is there a possibility for states just to be maybe shielded pushed in the right direction and to resort to better functions?
Yeah, thank you for this question. Absolutely. So I think that actually we've already seen it was what is particularly interesting with regional court that of course they are bounding the state of the regions. For example, the European Court is dealing with European state, but it's really interesting that we can see the court in Canada sitting the European Court. We can see the court in Israel sitting the European Court. So although they are not like it's not binding as maybe a European decision will be binding in Europe, but we do see how they refer to these cases and how it become actually a jurisprudence, a very important jurisprudence. So absolutely, I think that the regional court, now we have the European Court, but maybe also the Inter-American Court in their region and even beyond. Yes, I definitely think so, and we have example of it. It's very important.
Who was the gentleman? The lady.
No,
Sorry.
Thank you very much. I would like, first of all, also to thank the panelists for the presentation. And I would also like to congratulate for the books. I have read with a lot of interest the book by Dr. Weil. I will be very happy to read. I didn't know about the book written by Dr. Darcy, but I will certainly make sure to also read it. What I found, I'm working for the ICRC. I'm the head of the ICRC Advisory Service on International Humanitarian Law. And what we actually do and believe in So this is, there can be other opinions, but as we do that, we still believe in that through strengthening the domestic frameworks and integrating international humanitarian law within the domestic frameworks, we can reach better protection, better legal protection in armed conflict and uphold respect for international humanitarian law. This is why I was attracted by your book. I know that the ICRC has, of course, is convinced about the crucial role courts play in relation to IHL, and has mainly been following the more legal aspect, the jurisprudence, the development of the law, and the interpretation of the law. What is I found particularly interesting about your book is that you are analyzing the role courts play beyond the legal aspects, but how they can contribute or not contribute, weaken the respect of international humanitarian law. And this, it's a very important and interesting topic for us, which we will also, with our service, study a bit more in depth, look at it more in depth in the coming months, since we have a lot of interaction with domestic courts, but we would like to better understand what role they can play, what positive role they could play, and what they would need to play a positive role to strengthen legal protection in armed conflict. Now, I have a question. In your book, you, at some stage, you say that the situation is evolving, in particular speaking about jurisprudence, in the chapter dealing with the activities of the Supreme Court in Israel. You say that you see an evolution, and I would be interested in hearing from you what are the factors that can positively influence the role of domestic courts, also to become more courageous, maybe, and to really assert also better assert their role independently to remain independent from the executive, and to have a positive contribution.
Okay, so first of all, thank you very much. I think in general we see the things are evolving. I mean, first of all, the academy, how many lawyers we produce every year. You know, when I started my law degree, we have one course in international law, which was always also, you know, mainly the law of sea and things that, you know, so. Not the case in Geneva. Yeah, but so I think that in the last 20 years, we see a big change in the education and in the professional lawyers. So this is one thing. We have more lawyers. Now we have more and more legislation because of the ICC influence. So you have laws, you have lawyers, you will have cases. And this is why you can see this evolution over the I don't know, maybe 20 years or so in national courts. And I think this will continue because you have more and more NGOs. People are becoming more and more aware and more demanding accountability. I mean, who was asking to go to court before, you know? And now everybody is speaking about the ICC. Whether or not it will happen, it's another question. But there is this awareness of things. So now, what are the conditions to improve the jurisdiction? It's a complex one, and at the end, I'm proposing several factors, but I think that the entire process of education, of awareness, is very important, because if we are speaking about democracy, actually the demand of accountability is very important. And then, of course, legislation, when you don't have, it's very important, because without legislation, nothing can happen. And then to ensure that the judges, that when they maybe studied law, there was not yet IHL or human rights, so that you can see in some places to have more dissemination of this. And I think that the evolution that I saw, it was less in the High Court of Justice, because the High Court of Justice was quite, Israel was activist from quite the beginning. But I think we could see it in the US with the Guantanamo cases, and in the UK, and today with the European court, how courts are more and more, I think this is also a reason that the regional court actually, so courts are more and more, but maybe also you have,
No, I must just, may I add something? I think the question which will come up, which was not addressed, is the question of specialization within domestic courts. Specialization of public prosecution service as it exists now in France, in Switzerland, etc., and perhaps specialization of the courts, which has naturally an advantage because better knowledge, etc., and it does that disadvantage, like every specialization, to have different adjudications of cases which are not very different, and the fragmentation within a domestic jurisdiction of the law decisions making. So it's a very difficult debate, but I think in addressing your question and your thoughts, it's probably one of the most important topics which has to be addressed now.
Please.
Yeah, I mean, Sharon mentioned the International Criminal Court and the expectation that states pass national legislation. That just deals very specifically with war crimes, and IHL obviously goes beyond war crimes, and I wonder how we deal with the inconsistencies, the incoherency amongst the national courts. And I mean, the talk of an IHL oversight mechanism is politically not feasible, but it would seem that would be a suitable way of addressing that inconsistency. I mean, the question about the human rights bodies as well, I mean, they've been hugely significant in pushing the application of human rights in armed conflict. In fact, we see the ICJ relies on the Human Rights Committee in the advisory opinion on the wall to say human rights apply extraterritorially and during armed conflict. Then the ICJ cites that, and then the human rights body comes back and cites the ICJ in its concluding observations on the United States. So effectively it's citing itself, you know, and those are the sources that are relied on. So very, very, very influential. But would we see an IHL version?
And they will cite your book also. So it's all the
a circle. An IHL similar to what we see for a human rights body, I think, would be a way of addressing that inconsistency, but the feasibility is another question.
Yes, please.
Yeah, thank you. Development of international humanitarian law, yes, since the 19th, since the middle of, not necessarily since Nuremberg, but since 95, the end of Cold War, yeah. And we see that it was international court, penal court, former Yugoslavia, and in The Hague. But not only Serbian was concerned, but why necessarily in The Hague? Because later we said maybe it was better if it was implemented near former Yugoslavia, or Rwanda also, the same case. But there was also a court in Arusha city in Tanzania. And as I hear, national court didn't be set up by state, but by Security Council, and even, and I think Iraqi court didn't be set up by state of Iraq, neither by Iraqis, and Iraq didn't play important role. Yes, but what I want to say, because Rome Statute, it's important. Yes, we talk about Rome Statute without talking about ICC, and ICC was implemented, yes, thanks to Rome Statute since 98, then 2002, ICC. But nowadays, 12 years later, can we say, my question, yes, there is competitiveness. Can we talk about competitiveness between a national court and international court in applying international humanitarian law and international human rights law? Thanks.
I think that's yours. And then
Okay, on the location of the tribunals, yeah, I mean, that's been a criticism that they're far removed from the site of atrocities, that difficult access for victims and witnesses. And I mean, the ICC toyed with sitting in, I think, Uganda for one of the cases, but it hasn't happened. They are far removed. The initial rationale was security and things like that, but it is a criticism of the courts. It's separate from the issue of judicial development. But on the question of competitiveness, I'm not sure whether between international courts and national courts. I mean, national courts, under complementarity, there is some courts have a desire to show that they are dealing with these adequately. Certainly political powers want to be able to show that in certain circumstances. There might be competitiveness between judges, and Professor Sassoli talked about academic judges. I mean, you do sometimes see the stamp of a judge making their statement and getting their sort of academic work into judgment. With the Special Court for Sierra Leone and the question of amnesties, it seemed to be sort of pushing to be the first court that made a statement, a criminal court at least, that amnesties were unlawful. But competitiveness between the courts, I'm not so sure.
Yeah. You want to
just
give a little experience?
No, but just a cynical point, sorry for being cynical, but the judges who want more cases are at best the minority. No, but it's normal. You don't want more cases because you have so many cases to deal with. So the risk of having competitiveness is theoretically correct, but practically I'm not sure it will be the real issue.
Especially that the decision of international court are 300 pages, you know.
Which shows that they have time.
Yeah, international courts have time.
I suppose at the ICTY at the start they were looking for cases. They wanted cases managed, but now the question is has been over the past few years of getting rid of the cases to national bodies.
This gentleman was first, and perhaps then you, and then we conclude with some concluding remarks. Please.
Hello, I'm Michael. I'm from Germany, and I have two questions, but they're short ones. So the first one would be, in how far are the courts, the international courts, like the ICTY and ICTR, looking at national law when reaching a sentence, especially the average length of a sentence, let's say in Rwanda, when the ICTR pronounces their sentence on international law? And the second one is, you mentioned that there's a great diversity out there because there's so many institutions, so many courts, mixed or international, dealing with IHL. And would a treaty body, like we have it for other treaties, help in clarifying some things? And why is there no treaty body like this for IHL?
There will be, maybe.
No.
No?
Yeah, on sentencing, I mean, I don't really touch on it, but the ICTY was supposed to be guided by the national law relating to sentencing, but sentencing is an area where judges like to retain discretion. So, I mean, there's a lot written on making sense of the sentencing practices of the tribunals, and we have variations between them and within them. So, issue of sentencing, I don't think they've taken some guidance from national laws, but I don't think they've been sort of bound by it. On the question of a treaty body, maybe we'll touch on this.
No, you're right. No, but you're right. There are a series of things which do not work in the world of international justice, except the fact that it's in The Hague, which is another issue. No, but really seriously, there are a series, the point you mentioned, and one thing, in my experience, the most damaging thing is the absence of any control from an external body on the rules of procedure of evidence of the special tribunals. The ICC has a process, it's different. But for international tribunals are really completely free to change their rules without any even advisory board. And I've never been able to understand how in 20 years the international community system, I don't know, has not set simply an advisory board where the judges, before changing their rules, would just ask for an advice, not deciding, but you would appoint 5 former judges and just give an advice. Because as I experienced it, I was really uncomfortable with the process, where you have a judge coming with a proposal, and then the other judges decide, and very often the proposal comes from a case which the judge is not able to deal with, which is completely adverse to every sound tradition, be it in common law or in civil law. So there are a series of problems in the organization of international justice, which would be a topic for another panel, and one of the problem is the problem you address. And there should be something, for sure. The system is very, very unsound on many points.
On the treaty body, I agree with you. We need a treaty body. The ICC and Switzerland are engaged in a process of getting a better mechanism of implementation of international humanitarian law, but as far as I understood, states clearly said We don't want a body dealing with violation. Full stop. This is the great majority opinion of states. And strangely enough, they have accepted in human rights law something like that, because in human rights law they deal with violations. And yeah, I fully agree with you that we need human rights law to make sure, as far as we can, to have a little control, because states simply don't want to have. Now there will be a body, but the body will discuss on general problems and on national reports, on measures, and so on, but not with violations. And for the time being, it's states who make international law.
Yeah,
Yes.
Sorry, if I may just add on this, because of the distinction, why we have it in human rights law and we don't have it in IHL, because both of them are states. But I think this is exactly the demand of the civil society of the states, because the human rights movement in states was very important. I mean, you know, local, domestically, and then you have the demand of the constitution, etc. So there is the feeling that locally you have, domestically you have more the demand of human rights scrutiny, when in IHL is it maybe still need to be, because in armed conflict there is this view that the states know better what to do.
But don't redraft history, because when the European Court of Human Rights was set, civil society didn't exist. It's the shock of the Second World War which leads to the main European body on human rights law, not the civil society at the time. And naturally, now the civil society is a support against states which want to either to remove the officer, to be out of the system, or to change it. But at the beginning, it was top-down, not bottom-up, at the beginning. And at that time, there was not such initiative on humanitarian law. I don't know, I haven't studied, but it would be interesting to study the reason why there was this movement on human rights, and not on humanitarian law. Probably you know better than me, but don't say that at the time it's the civil society.
Well, in the but it's 1966, is the colonialization process.
No,
it's in the 60s, the treaty bodies.
No,
I'm speaking about the treaty bodies, sorry,
We have 6 more minutes. Mrs. Belal, and then Mr. Samaruga wanted to give a... Please.
Thank you very much. Well, first of all, I would like to congratulate both you, both Shane and Sharon, for the books, which I really look forward to read. I have a question for you, Sharon, perhaps. You have talked about the relationship between judges and their state, for example, with regard to the political question, avoiding some issues that are too political or not. And I was wondering, because you talk about armed conflict and we talk about IHL, if the judges had different attitudes toward the law, or even towards facts that they were evaluating when they were dealing with armed non-state actors. I mean, were they more lenient? Were they more objective? Were they more subjective? Would you apply the same kind of methodology that you had, the same kind of, categories, when cases were dealing mainly, for example, with, violations of IHL committed by armed non-state actors?
This is a good question. I need to think about this. I'm not sure I have examples. I need to think about this. For example, when you have, in Israel, when you have non-state armed groups, so they are prosecuted by the military courts. But I think then it will be again the same, and then when it is an internal and non-state actor, so you name them terrorists or you name them whatever. Now, if it's a criminal prosecution, then it will be more easy, so the case will arrive to the justice than if it wasn't. But then I think it will be just the same. I don't remember to have example of this but I believe it will be just the same. And then it will be maybe easier for a court to pronounce itself on non-state actor. And maybe it will be easier for it to just apply the law as it is. Yeah.
Mr. Samaruga?
Well, yes, Cornelio Samaruga, a man of the past. Marco Sassoli, when I came, was very astonished. What have you for an interest to be here? Well, I would like simply to recall that 20 years ago, as president of the ICRC, we made a tremendous pressure on the International Law Commission. Each year we had meetings with them. There was a famous ICRC dinner in July for them. They were coming with pleasure to the dinner, but before the dinner, we always had a sort of meeting with our lawyers. Probably Marco Sassoli was also there in order to push for this international criminal court or such a kind of criminal jurisdiction. I also was involved in the Statutes of Rome, and then I was following what happens. Now I have a question particularly referring to what Marco Sassoli said a few minutes ago about the violations and the way in which this could be made in a certain way, an awareness for states. And last week there was here a lecture by the present president of the ICRC, Peter Maurer, and he spoke about a World Humanitarian Summit. I wonder if this is a case where this problem will be discussed by governments. Do you know it, Marco?
To my knowledge, not. It is about abstract issues. And probably it is correct that to discuss about violations, you need a permanent body or a body which will come back and back. One short conference to discuss about all the violations is, in my view, not necessarily the right thing.
But it could institute a body too.
Okay, absolutely, that's a good idea. So, who of you has, would you like to make a concluding remark to our discussion?
Thank you very much.
So then I thank you, for those who have made questions and those who didn't ask questions. Otherwise my task would have been